Good evening, everyone. My name is Gagan Kumar. Uh, I am the sitting president for Delhi chapter of Indian Lawyer Association. Welcome to the monthly meeting of Indian Lawyer Association. We keep organizing our knowledge management meetings where we endeavor to keep our members updated on the development in the legal field. Today, we intend to discuss a very important development. The Parliament recently passed Labour Code, which encompasses four labour codes, that is, Code on Wages 2019, Industrial Relations Code 2020, Code on Social Security 2020, and Occupational Safety, Health and Working Conditions Code 2020. These laws essentially substitute various earlier labour laws which were overlapping and creating redundancy and duplication as well as contradictions. Almost 29 labor laws have now been repealed and have been subsumed in these four laws. These laws are likely to be enforced with effect from April 1st this year. While the rules are still being drafted, we considered it apposite to have a look at these laws and understand the implications which these laws may have on the practitioners as well as on the industry. To take us through these new legislations, we have with us our secretary and partner of VGA Legal, Ms. Soni Singh. Soni has been an old colleague from our Amarchand days, as well as a dear friend. She is an alumni of CLC Delhi and did her master's from King's College London with emphasis on comparative law of copyrights, commercialization of intellectual property, and European Union competition law. Her biographical facts don't come close to her personality. She is a trailblazer, pioneer, and daring lawyer. Uh, Before she begins, I wish to share a sad news that father of one of our member, Swami Dharmendra, passed away last night. He is also a colleague of Ms. Soni Singh and a very active member of our organization. May I request to please pray for the departed soul. Now, please join me in welcoming Soni and let us hear more from her on new labor code. Soni, all yours.
Thank you, Gagan. I have never been better introduced. Thank you for your kind words. And I see that we are a few participants. What I will do is I will take you through the basic features of the law because as we understand, these laws are very ambitious in its application, because to try and cover around 44 central laws and replace 44 central laws and over 100 state laws. So obviously the central laws are not replacing the state laws, but because labor falls in the state list as well as the central list, the central acts, what they have, the central codes which are being promulgated, and what they have tried to do is, so far as possible, give the minimum thresholds even for state laws, so that there is a minimum disparity in different parts of the country. And therefore, it's a very ambitious project that was taken up. It was taken up in about 2002 by the second National Labor Law Commission. I don't know why something is coming in the window, but I will just let it be. Like something is showing, please move this window. Anyways, so that I hope it's not disturbing the recording, and I'm going ahead. So this effort, this exercise was started under the Vajpayee government, and the second National Labour Commission was appointed to take up the task of proposing new laws, new 4 to 5 codes encompassing the 29 existing labor laws. In fact, there are 40 central laws, if one can see, like 40 central laws which are there which were existing or which are existing even now. And these new codes cover 29 of the 40 central laws, covering various aspects of labor and employment in the country. The idea is to bring about more flexibility and definitely to encourage ease of doing business in the country. My slides are very detailed, but I will try and take you through the main points only. So as Gagan has already pointed out, the 4 labor codes which have been promulgated are the Code on Wages, which was passed by the Parliament in August 2019, and the 3 other codes which were actually passed in September 2020, the Industrial Relations Code, the Code on Social Security, and the Occupational Safety, Health and Working Conditions Code 2019. So these are the 4 codes that have been promulgated, that have been passed by the Parliament in 2019 and 20, covering 29 central labor laws. So we begin with the Code on Wages 2019, and let's try and understand some of the key features. So we already discussed this. It received, the Code on Wages was the first one to be passed in the Parliament. It was passed in 2019 itself, but because the government wanted all the 4 codes to come into force simultaneously, this was held back and has been held back, and the rules are being framed. And it is the intention of the government that the rules will be framed and the laws will come into force before April 1st. Whether this will cause some kind of unrest, we do not know, because there are certain provisions regarding labor that have been changed, and there are certain major changes, but they are mostly aimed at, and the focus of the laws, as you will see from the key features of the enactments, is basically to decrease the kind of mesh of laws that was created. And there are so many laws that were there for a business to be set up and to for a business to follow and comply with. It is a complete maze that we had. So the idea is to make it all into some uniform and some easy to comply rules, which are all consolidated into these 4 codes. And so far as possible, the idea is also to sort of give some guidelines to the state laws and some provide some minimum thresholds, so that the state laws also more or less are in the same manner they are made and promulgated. So the Wages Act subsumes 4 acts: the Payment of Wages Act 1936, the Minimum Wages Act 1948, Payment of Bonus Act 1965, and Equal Remuneration Act 1976. Some of these acts we did not even know that they were there. Like there was an Equal Remuneration Act, but it has the new code tries to bring out some more changes to it to make it more effective. The first thing that is very notable of the Code on Wages is the coverage of the Wage Act. It actually covers for timely payment of wages and the minimum wages. It sort of covers all employees, irrespective of wage ceiling and sector. It seems to cover anyone, whether it is in the organized sector, unorganized sector, in whichever sector you're working, you may be covered under the Minimum Wages Act. And there is a floor wages that will be prescribed by the central government by notification. And it seems that that floor wages will be the actual minimal that even the states would have to follow. So anything above that is possible, but anything below that cannot be possible throughout the country. So that's the floor wages. It will be fixed by the central government, considering the living standards of workers different for different geographical locations. Then minimum wages, as earlier, will be specified, notified by the central or the state government, but it should be not less than the floor wages that is notified by the central government. Are we okay with? Um,
Yeah, Soni, carry on.
okay. So the definition of wages, it's the code seeks to provide a single uniform definition of wages as applicable to minimum wages payment of wages and payment of bonus. By definition of wages, if some of you have practiced under the labor codes and the labor enactments, then what is included in the wages is also a subject matter of a lot of disputes. What is included in the wages, what is not included in the wages. And that's something that one has to see, that now this code says that suppose the wages is the wages first of all include certain things, like they include the basic salary, and they include the dearness allowance and the retaining allowance, and it excludes something like value of house, etc., depending on the state government enactment in this regard. And provident fund, etc., could be excluded. Some overtime charges could be excluded, and things like that. But what is to be noted is that if the sum total of excluded components, so all the excluded components, if they are more than 50% of the wages as notified, then the portion which is excluding, the portion which is exceeding 50% of exclusions will be considered a part of the wages. So at no point of time, and this is slightly complicated, like read it to understand it, but it is like all the exclusions, if suppose the wages that are included as to be counted as wages is 50% and your exclusions become 60%, then the wages will be 10% of the exclusions will be added to the wages, and your wages will be considered, so that at no point wages is less than 60% of your entire receivings. So that's how your wages, or the wages, will be considered. So there's some kind of, at least this sort of helps, because there has been, as I said, a lot of litigation over what is included in the wages, how much will be included, how do you count the wages, how much is the exclusion. So all that, this will be helpful to calculate or to understand. Maybe there will be new type of litigation, but we have to yet see that. So another thing that is important in this act is equal remuneration. So we've kind of covered it under gender discrimination. So there will be no gender discrimination, and it is on the basis of gender. You cannot for the same kind of work that is done by same kind of employee and same nature of work and same number of hours put in, then the salary has to be the same, or the wages have to be the same. and you cannot discriminate on the basis of equal remuneration on the basis of Code on Wages Act, Code on Wages. Though the Equal Remuneration Act also provided something like that, but there what is to be seen as remuneration was not really clear. Now, under the new code, wages have to be seen, even for the purposes of maintaining no gender discrimination. And so we've talked about, so I would say the three main key features of the Code on Wages would be, first of all, its uniform application across establishments. And you will see that actually certain kinds of employment were covered under the Minimum Wages Act. There was a scheduled employment under the Minimum Wages Act. Here, it seems to cover the floor wages. For the floor wages, all sorts of establishments are covered, and it seems to cover across any sort of employment. And then the second feature, which is very important, is obviously the feature regarding floor wages, which is which will be uniform across the country. And then obviously the gender discrimination feature, which says that they cannot be, which seems to be more clear in the terms of how gender discrimination should be avoided, and how it should be maintained in a better way. Let us now come to what seems to be the most important one of the codes, is the Industrial Relations Code. And this code, again, was passed by the Parliament on September 2020. None of these codes are yet in force because the rules are yet to be framed for those who joined later. So they are yet to be brought in force. And the Industrial Relations Code covers the Trade Unions Act 1926. It covers the Industrial Employment Standing Orders Act 1946, and obviously the Industrial Disputes Act 1947. So the main two acts you will see is the Trade Union Acts and the Industrial Disputes Act. And what we should note is these are acts of 1947 and 1926 and 1946. So obviously they have been in force for a very long time, and times have changed. And what is very important in this particular code is that it tries to cover something like what are called gig workers and what are called platform workers, and it is trying to be wider in its coverage area, and it kind of tries to provide for everyone. Plus, it tries to become more flexible for businesses in the terms of the businesses covered. You will see for certain kind of provisions. Earlier, it was the moment if you have 100 workers in the preceding 12 months, then you will be covered under the act for making any you need a permission for layoff, retrenchment, closure of your business. But now this minimum threshold has been increased to 300 workers. And similarly, for various other provisions, so the threshold has been increased, keeping in line with the current circumstances, and that for 100 workers may have been considered. And this is a provision which seems to be not running very well with the labor who feel, and the labor unions and trade unions. And there are other features regarding trade unions that you will see that the way strikes have been regulated under the new act, it seems virtually impossible to have a strike under this act. So these are certain provisions that may face some opposition if they have not already faced it. You will note that these laws were passed in the parliament when the opposition were keeping away from the parliament on these sections. sessions, but there were committees which went through the law, and it seems it did not receive, and so far it does not seem to be um, garnering any opposition or any kind of major upheaval regarding this. It does, in fact, it does help. It does seem to cover migrant labor also in a wider sort of way, so that to uh, overcome the crisis that we covered, which we faced during the lockdown. So situations like that, and to cover and to envisage to cover situations like that, the definition of migrant workers has also been widened. So those were the broad things. Then now let's just go through some of the key features. So worker. The earlier Industrial Disputes Act, you would see that the worker is defined as someone who is not working in a supervisory capacity and earning more than earning less than 10,000. This is now brought to 18,000, and anybody even in supervisory capacity would be, if the person is earning 18,000 per month, then he would be covered as a worker under the act. Then there are rules regarding standing orders. So again, this standing orders is certain rules which will govern how the workers are expected to work, and how what are the rules that are applicable to workers. They have to be properly informed about it, like matters related to classification of workers, manner of informing workers about work, holidays, pay days, termination of employment, grievance redressal mechanism. So these standing orders needed to be in place in any industry under the Industrial Disputes Act and even Industrial Relations Code 2019, when the bill was still under consideration. It was the minimum threshold here for having standing orders in place was 300 workers, was 100 workers only, but now it has been changed by uh, reconsideration, and there has been an amendment to the 2019 bill, and the 2020 bill was proposing 300 workers, which has been accepted, and that's how the act has the provision that it is applicable. So any establishment having at least 300 workers, so up to 300 workers are exempted, and beyond 300 workers, they have to have certain standing orders. And if you go deeper into the act, you will find that these standing orders need actually to be certified, and there are certain model standing orders which are prescribed by the central government. If you adopt them, they have to be considered certified on their own. And if an establishment actually places a standing order for the consideration of the authority, and it is not certified within 60 days, it will be deemed to be certified. So again, ease of doing business seems to be the focus when you do this, that you have deemed certification, so you are not lingering with whether it is certified or not, and waiting endlessly. Like you would know, in RERAs there are certain deemed certifications under the RERA Act also that are recognized. So permission for closure and layoff, again, so these are two of the more important provisions apart from the definition of worker. So I have already discussed this, that earlier only if you were employing 100 workers, then you had to take permission for um, any for the concerned government before any closure or layoff or retrenchment. Now this is the minimum threshold is 300 workers, and therefore it has been substantially increased. And one thing is notable, that earlier the IR code the Industrial Relations Code in the 2019 version actually allowed the state government or the appropriate government, as the word is used, the appropriate government, whether the central or the state, to increase or decrease this threshold. Now, as per the new IR code, this threshold cannot be decreased. So it can be increased by the appropriate government, but it cannot be decreased further. So it cannot be made to 100. So 300 is the minimum number for application of permission for closure, layoff and retrenchment. There cannot be a permission prescribed by a state government where less than 300 workers are there. So these, apart from these, what in retrenchment, there is a worker reskilling fund that has been prescribed to be created by the appropriate government, and there are contributions required to be made by the establishments to a certain extent, like 15 days of wages of the employee, and certain contributions by the appropriate government as per schemes that they may lay down. Now the important provisions are as regards the unions.
Soni, sorry for interrupting. We will maybe running out of time very soon. So should we go for the questions or if you have to cover
Let's
some
just
aspect
finish
of it?
IR code so that this is the main code and I am almost at the end of it. Let's finish this one and then we will
All right. Thank you.
wrap up and let them ask questions. Right?
So we'll have essentially about 8 to 9 minutes left. So
Just 1 minute more. Okay. So what is important in the Industrial Relations Code, people, is about strikes and lockouts. I wanted to talk about this because you have to now give a notice to if you are going for a strike, and there are various stages of notices, so one has to understand, and it's virtually impossible, it seems, to have a strike. So but there is an arbitration and conciliation mechanism for the benefit of the labor, and then there is a very important point of having a negotiating recognizing a negotiation union. So various establishment often found there are more than one unions that they have to deal with. Now the act says that if one particular registered union has more than 51% or up 51% enrolled in the master rolls of that establishment, then that union will be recognized as the negotiating union. And if that cannot be done, there's a method of having a negotiating council. So this is to make it a bit easier again to do business and to manage the workers and strikes and how to deal with trade unions. And this is also a very important thing that is being done under the IR code. So I'll stop here. I did think this was a mammoth exercise to go through these 4 codes in such a short time, but thank you for hearing me out, guys.
Thank you, Soni. This is very helpful, and I'm sorry for curtailing it in between. I know one of the other important aspect on code on social security, people would have wanted to know more. But just to begin the conversation and have very quick questions, and I will take the liberty to ask first question. Now, in terms of applicability of Provident Fund and ESI, I understand that the basic wages have to be not less than 50% of the total wages. Is this correct? My understanding is correct, and you have any thoughts?
So basic wages, what the code says, that when you consider what is wages, what portion of your entire remuneration is wages and what is not. If suppose you are receiving, and this is not regarding provident fund and gratuity, etc. These are like the components like house rent allowance, like bonus, like overtime payments. So which will be considered a part of wages and which will be not, to consider whether you are covered under that 18,000 threshold limit. So that is the thing which under the wages, under this code, what they say is that if there are certain things which are definitely included in the wages, which is the basic salary, the dearness allowance, and certain other components, and certain things have been left to the state or otherwise, which are not included. But when the excluded portion becomes more than 50% of the included wages, then the excess portion will be counted as part of the wages. And therefore, so if I have wages of 10,000 rupees and I have excluded portions of 15,000 rupees, my wages will actually be counted as 15,000. That excess amount will be added to my wages. The excess of the excluded portion. Excess of the excluded portion.
Thanks. Rachita, you have any point? Anybody else? Muzammil, Avdesh, Tanvi, Karuna?
Thank you, Muzammil. I really like that being a patent lawyer, you are taking out time and listening to the labor codes. I really appreciate it.
Shows some dangerous sign also.
Oh, actually, I wanted to hear like what exactly is happening and why there's so much noise
There
around
is,
this.
Muzammil, I
Yeah,
think we should all read it because it is going to have a very wide
yeah,
application, particularly the social security codes, which is something that I think all establishments should look at, because social security code really widens the net. And even the floor wages concept, which is applicable to anyone and everyone, it seems, as an employer.
totally, totally.
But does it really help in having the sense of ease of doing business, or is it adequately covering the interest of laborers as well at the same time?
Gagan, to a certain extent, there is an effort when you can see that. But as I said, like some people like platform workers or gig workers. Now, platform workers or gig workers would be people who are working with aggregator companies or who are working on online platforms. They have also been covered under these codes. But how they will benefit or which scheme is for them, that has still not come about. So the schemes have to be still laid down. So you have to really see how it unfolds. But yes, there is an effort to ensure ease of doing business by perhaps increasing the thresholds, by regulating the trade unions, how they can strike and all that stuff, and by making some standard operating procedures, how you can just get it certified in a very easy way. And also, what I did not talk about is there will be one industrial disputes tribunal. There will be less of various kinds of forums, perhaps, that one will have to go to. So there will be a conciliating officer and there will be industrial disputes tribunal, and hopefully there will be no maze of authorities and tribunals that you will have to go to.
That's comforting to know that people who are working with aggregators, so they are currently being left out with no social security because
Yes.
they are
Yes.
principal to principal basis, but at least now there will be a master servant relationship, so they may be entitled to certain social security benefits. Thanks a lot, Soni. I'll take liberty now because we are almost come to end. Rachita, I think you wanted to say something.
Uh, no, Gagan. It was a very, very great session. Thank you so much for enlightening us. No
So,
no question in particular.
well, you've been flawless, Soni, as always. So no questions. You've made all of us very intelligent now. So we'll be able to understand more. And I wish to have one more session to cover the remaining aspect. And we'll look forward to have you again, once again, on this platform of ILA. Thanks again. Thanks everybody for joining in. And I know it's Wednesday, middle of the week. Thank you. And thank you, Soni. And I know Dharam has been your colleague, and it's a great loss. We'll try and make way very soon. Thank you.
Thank you, everyone.
Yeah, thank you so much. Bye bye.
Thank you.
Thanks.
Bye-bye.